So hey everybody, Shelby Miller with Keller Williams Realty, and today I am with Rick Howard with Weber, Kraft Chellew, which is a local law firm that is in Perkasie, Pennsylvania. And thank you, Rick, for talking with me today.
Thanks for having me, Shelby.
So Rick, I wanted to talk to you today a little bit because you and I had a conversation the other day. I have a buyer who during this whole COVID-19 has put an offer in on a house sight unseen and received the seller's disclosure. And the seller's disclosure mentioned a small insurance claim that they were aware of. But when they contacted their own personal insurance company to find out about anything on the house, there was an additional water claim that the seller did not disclose. And I wanted to kind of talk to you about that and have you explain to viewers, especially those that think that because you can't walk into a house right now, you might not have to disclose everything, and what legal issues might be there.
Well, and that's a really good question, Shelby. So the thing is that when you're selling a home, one of the things that you're required to do under Pennsylvania law, and of course, I know you and any good realtor are going to be telling your prospective buyer this, and also a listing agent is going to tell their seller, is that you have to accurately and completely fill out the seller's property disclosure statement. That's there for a reason, and it's there to let people know if you're having issues of any kind with the home, whether they be maintenance issues, repair issues, mainly major issues is what it comes down to. And it's typically the type of thing that a buyer is not likely to discover either themselves, or if they have a home inspection, it would be to alert their home inspector too. But the thing is that if you are listing your home virtually and you have a buyer who's not walking through, there are things that they're by definition not going to be able to observe. And that doesn't minimize or get rid of the obligation to provide accurate, complete information on the seller's disclosure statement. It enhances it, because the thing is that if you as a seller are aware of something, let's say for instance, one of the main types of things that I've seen have to do with water intrusion or mold. And if you are aware that there's a history associated with this property that a buyer by definition isn't going to readily observe, you have to almost live in the home to experience this, then it's incumbent upon you, the seller, to divulge this. And the fact that the buyer can't get in to look at it doesn't mean you can say, aha, this is like a get out of jail free kind of thing for me. In fact, what it does is if you don't divulge it, it can cause problems. It can cause problems during the home inspection. It can cause problems up to time of settlement. It can cause problems after settlement. I've lived situations where I've represented former sellers who have been sued by the people who ended up being their buyers, because the fact is that the seller had been accused of not divulging accurately on the seller's property disclosure statement what was a major issue of some kind. And the thing is that
I have a question for you, Rick. So is there a length of time that, let's say a buyer moves into a house and they say that they've never had any issues with water in the basement ever, and all of a sudden they have one storm and the basement completely floods? Is that something that a buyer could go back to the seller, and is there a length of time that they have that they're allowed to try and find some type of mediation?
Yeah, well, that's a great question. Under Pennsylvania law, for a breach of contract claim, you've got 4 years. For tort claims, it's 2 years. And the thing is that, after the time of settlement, after settlement occurs, once settlement has happened, basically what you could do is you could experience something. And if, let's say, within that couple of year period, there's a water claim of some sort that you learn that there's a history to, that the seller should have divulged, but they didn't, then the buyer could go back against the seller. And I've seen them not only go back after the seller, but they go back against sometimes one of the agents. They, particularly the listing agent, they'll often go back against the home inspector who they think did or should have discovered it. But the thing is that it all gets back to, if you as a seller are selling a property, it's not it's not the get out of jail free card that's, somebody doesn't get a chance to look themselves, therefore I can under disclose. It's going to be really critical for you to completely and accurately fill out that seller's property disclosure statement. And if you don't, you can end up in court. And the thing is that you end up having to hire your own attorney to defend you, which costs a lot of money. So the downside to not disclosing is such that why put yourself in a position to even have to worry about that? If you have any doubt whatsoever, if you are a seller and have any doubt whatsoever as to whether to disclose something, I always tell clients, err on the side of divulging it, because you want these issues to come out. If they need to come out, then you want them to come out during the negotiation process, during the inspection process. Yeah, is it uncomfortable? Is it inconvenient? For sure. But the thing is that that's better than having to worry about on the back end being subject to a lawsuit, is what it comes down to, if that makes sense.
Absolutely. Rick, I thank you so much for taking the time to just kind of explain the legality issues. And, you and I have been friends for a very long time,
Yeah,
and you are a phenomenal attorney. And
I
I would
I
100% recommend, and I have referred people to you that sadly have needed your services, but there might be someone that is currently thinking that they may need some type of legal service, hopefully not because of a seller's disclosure, but how
hopefully not.
can they reach you right now if someone wanted to?
Well, and during the COVID-19, it makes it a little bit more difficult. But the thing is that you could always send me an email at rhoward@wkclaw.net. You could also reach our office, and it will be forwarded to me at 215-257-5114. And of course, if somebody reaches out to me through you, you have my personal cell number, which I'll leave it to you to decide whether to give to somebody. You always use real good discretion on that. But I'm happy. I'm
Absolutely.
happy, and I'm ready to help anybody. Is what it comes down to. And the thing is that it's really important that people get good legal advice, and that they have an attorney who knows what it is that they're doing, and they have somebody who's a knowledgeable and skilled realtor like you, who's going to steer them in the right direction, that before they need counsel, they're gonna do the things that are necessary so that they minimize the likelihood of having to get an attorney. But I really appreciate the opportunity to come on to this, Shelby, and to have this discussion. I love discussing legal issues, as you know, and they're like
Thank you.
solving pieces of a puzzle for me. But I recognize at the same time that there are real world problems suffered by everyday people, and that's part of what it is to try to find solutions. So if you can find solutions on the front end, maybe you don't need me, but if you do, I'm here.
Thank you, Rick. I appreciate you, and I hope that you have a wonderful day.
You too. Thanks, Shelby. Have a great
Thank
day.
you.
I hope everybody is staying well and safe, and they're following your good advice on filling out that seller's property disclosure statement accurately.
Thanks, Rick.